This is a love affair, the ballad of John and Leon in many ways, what has evolved in Dhaka. I'm here as a son, I'm not here as an immigration practitioner. And I'm here as an aside to urge everybody to be in touch. If in your case or in your home, in your world, somebody presents and we could be a resource to you. We actually have the old FOIA file. We have been consulted by immigration lawyers for decades, and Dad is trying to put a book together for almost 44 years on this case, where we feel that we could be of resource to you. In your library should be Shobha's book. It is a treatise on this, the first codification of the authority that was penned in this. I teach a class now where Dad taught for so many years at Ferdosovo School, and I can tell you whether it's cannabis, the use of FOIA, or other tools, you should reach out and feel free to be here. This is a rock star, not just in our household, but in the halls of AILA, a former president, and I now introduce to you my best friend, my mentor, Leon Wild.
Thank you. The deportation case of former Beatle Lennon and his artist wife, Yoko Ono, took place when they were here as visitors in 1971 to 1972. They had obtained visitors' visas at the U.S. Embassy in London, where John also applied for and got a waiver of his ineligibility for residence and admission to the United States because of his conviction for possessing cannabis resin. They came for one single humanitarian reason. Yoko had a child known as Kyoko who was in the United States. The child was from her former husband, Anthony Cox. And Cox had succeeded in preventing Yoko from seeing that child for several years while John and Yoko scoured all over Europe following him around, and they were unsuccessful. They came to the United States and they started a proceeding for custody in American courts. Her husband filed an opposing proceeding. The judges in both cases granted John and Yoko custody, and they held her former husband in contempt for failing to allow him to allow her to see the child. There's something that we must remember about 1972 as well. Not just that I'm a slow writer and I just finished my book on the case. 1972 was the first year that the voting age was reduced from 21 to 18. And as a result, it empowered some potential of 10 million new voters. Now, President Nixon was sending off all those young people as recruits in Vietnam in a serious war that had already cost the nation over 50,000 sacrifices. Despite his promise to try to end the war, he seemed to be expanding it, and he realized that these young people are not going to endorse his re-election in August, at the end of 1972. I was retained to secure additional time for them as B2 visitors. And I did my best, but for some reason, the government not only denied all the extensions, but they also started deportation proceedings. And in my 58 years as an immigration lawyer, it was the only case in which my clients and I were twice served at home and in their office with orders to show cause commencing those deportation proceedings as overstayed. Now, it was very, very hard to explain why this drastic action was taken against these wonderful people who were here for such a noble reason. What had happened? Well, I found out that there were several things had happened. About a month before I represented them, John and Yoko appeared at a rally for a musician named John Sinclair. The 10 for 2 rally, it was called 10 for 2 because John Sinclair had been imprisoned for 10 years for possessing 2 marijuana cigarettes. This was Lennon's first appearance after the breakup of the Beatles 5 years earlier, and he sang a song which he composed for the occasion. It Ain't Fair, John Sinclair. John and Yoko appeared at 3 a.m. in the morning at the University of Michigan at Ann Arbor, and there wasn't an empty seat in the theater. And permit me to say that the theater housed 15,000 people. I must assume, however, there were quite a few FBI agents there. A few days later, Michigan law was changed. The Michigan legislature reduced the amount of time that one could spend in jail for possessing marijuana to a maximum of 6 months. And based upon that, John Sinclair was liberated. John was immediately released, but he attributed his success to the presence of John Lennon. Another thing that happened, which caused the INS to deny the Lennons a simple routine extension of their visit and treat them so badly, was that South Carolina Senator Strom Thurmond wrote a letter to his friend, Attorney General John Mitchell, and he enclosed a memo from the Senate Internal Security Subcommittee of the Judiciary Committee. Mitchell held 2 important jobs that were significant in Lennon's case. First, he was the Attorney General in charge of the INS and Justice Department. Second, he was the chairman of CREEP, the Committee to Re-elect the President. One wonders which hat he was wearing when he read the letter from Senator Thurmond. The letter to him, addressed Dear John, said that this appears to me to be an important matter, and I think it would be well for it to be considered at the highest level. Now, there was only one higher level. And as I can see, he said, many headaches might be avoided if appropriate action be taken in time. So it was clear that Mr. Nixon was being told, get this guy out because of your re-election plans. The attached memo referred to John Sinclair rally, stating that radical New Left leaders, Rennie Davis, Jerry Rubin, Leslie Bacon, Stu Alpert, Jay Craven, I wasn't familiar with these names either, formed a group that were strong advocates of a program to dump Nixon, and alleged that they had devised a plan to hold rock concerts in various primary election states to stimulate the 18-year vote registration and to recruit persons, if possible, to come to San Diego to attend the Republican National Convention in August '72. So I was right there in the middle of this entire thing, and I didn't realize it. He said they intend to use John Lennon as a drawing card to promote the success of the rock festivals and rallies. John hadn't even agreed to do this, but it was their intention to try to convince him to do it. A copy of Strom Thurmond's letter was sent to Bill Timmons, the White House liaison to the Congress. I also learned that some other nefarious activity had taken place. The Commissioner of Immigration in Washington telephonically advised the New York INS director to immediately revoke the voluntary departure period that John Lennon and his wife had been granted, and that under no circumstances was their application for consideration in the old third preference as outstanding artists qualified to apply for residence should be approved. A direct direction from Commissioner Farrell personally. That was one of the documents we discovered in court a few years later. What had happened was that my client's case was being prejudged by the government. It gave me an early taste of what we later began to refer to as Watergate tactics. The New York District Director and the Commissioner's Office were besieged with inquiries and letters and complaints about why the Lennons were subjected to this unexplained harsh action, and we got no explanation about it either. The government uniformly stated that the Lennons were being treated like any other illegals, and that the government cannot choose which aliens to place in removal proceedings and which to allow to remain. Day after day, statements were issued by immigration officials on TV who could be watched on a daily basis, and thousands of letters were sent in response to everyone's inquiry about why they were being treated this way. Their statements to that effect were unadulterated lies, and they knew them to be false. Thousands of letters were issued by INS in response to so many inquiries from people in all walks of life, totally misstating that what the commissioner and the district director knew to be the true facts, that there was indeed a procedure used for many, many years to allow executive action to exercise prosecutorial discretion and permit some illegal aliens to remain. Among the lawsuits that I brought for Lennon was one under the Freedom of Information Act, and I believe that that was the first immigration case in which the Freedom of Information Act was used as a litigative tool. After the usual delays and motions to dismiss my lawsuit, and after engaging in a long-term correspondence with the INS, I finally succeeded in learning that there was a non-priority case, that there was an unpublished operations instruction. I was told that they were in the blue copies of the operations instructions, which were never published. I guess they were just trying to cover up for years and years of lying. Under the guidance of the U.S. Attorney in the Southern District of New York, the pertinent operations instruction was moved later on was moved from the blue pages to the white pages, and was published. And as an operation instruction, I learned that every case, the statute, the operations instruction said, quote, in every case where the district director determined that adverse action would be unconscionable because of the existence of appealing and humanitarian factors, he shall recommend consideration for non-priority. The OI also listed certain factors that should be considered as advanced or tender age, many years presence in the United States, physical and mental condition requiring care here, family situations in the U.S., the effect of expulsion on the family, criminal, immoral, or subversive activities, recent conduct. Under the Freedom of Information Act, the government furnished me with 1,853 reports of these non-priority cases. We'll refer to them as deferred action, but their original name was non-priority. I set about to analyze, categorize, and publish my findings in a series of articles in the San Diego Law Review with the encouragement of my client. John Lennon took a special interest in seeing to it that what I had discovered to help him could be used by others who might not be able to go through this kind of litigation. The procedure followed by the district directors at immigration was exactly the same in every case. A district director made a recommendation to his regional commissioner. It was a one-sheet form that he filled out with the essential facts of the case. And the regional commissioner, if he recommended it, would recommend it to the commissioner in Washington. And then the application could be approved. If the commissioner accepted the recommendation, from that point on, everything was secretly kept. The file would be put away, and but once having effected this by placing these in the operations instructions, which all of us could refer to, I had killed the government's secrecy. I'm quite certain that on specific dates that adverse action was taken against Lennon and Yoko. The district director in New York was also recommending a non-priority case. And when he was interviewed on TV or even at his own press conference, which I attended with some helpful reporters who allowed me to pose some questions to him, and I had a secretary there to take down the questions and the answers. He lied through his teeth about the procedure. It was about a year after the INS published and revealed its OI on non-priority that the General Counsel of the Immigration Service, Sam Bernsen, published a legal opinion about the use of prosecutorial discretion in immigration cases. In his opinion, Bernsen identified decisions dating back to 1909 in which the INS had exercised their discretion. And besides stressing the importance of and suggesting that the government act as early as possible, hopefully before deportation proceedings were commenced, he also noted in his report. The, quote, intolerance for situations where individuals are selectively prosecuted for political or discriminatory reasons. He was referring to the John Lennon case. The federal courts reacted differently in various federal regions. In the second district, in the Second Circuit in New York, it was held that the non-priority category was an informal administrative stay of deportation, not essentially a part of the alien's entitlement. The Eighth Circuit recognized it differently and considered that applying for non-priority or deferred action status was a right. The Ninth Circuit considered it to be operated like a substantive rule and stated that deferred action confers a substantive benefit upon the alien rather than merely setting up an administrative convenience. There was a short period of time during which the OI disappeared from the operations instructions. And I think I almost had heart failure. It was transferred to a different volume, standard operating procedures under a quote unquote housekeeping policy. Well, I didn't really trust them, so I looked into it. In any event, what we had done had made it so public, that it was impossible to hide it in the future. The leading treatise on immigration law stated that while the deferred action program is still an internal administrative arrangement with no provision for an application by the alien, it's appropriate for the alien or the alien's counsel to call to the attention of the district director the circumstances of a particular case with appropriate documentation and to suggest or request that consideration be given. There finally came a time in the Lennon case when I asked the government to consider John and Yoko for non-priority status. Actually, I have a letter from a deputy district director after the district director retired denying it. But I found that the file was not in his possession. It was with the U.S. attorney, and he could not have even looked at the file to write that denial. Paul Curran, the U.S. Attorney for the Southern District of New York, wrote a letter to the Judge Owen, who was hearing our case in federal court, with a copy to me. He stated that at his suggestion, and without implying that their previous action was incorrect or irregular, he had determined that the INS undertake a review of the question of possible non-priority classification for Lennon and assured the court that no official who had any previous connection with the case would be involved in considering deferred action for Lennon. Luckily, that deputy district director was out of the picture. I drafted a beautiful affidavit for my client, John Lennon, setting forth his hardship in the case, namely that his wife, Yoko, had a long, difficult history in childbearing, and that he had committed himself to sharing her pain and offering his love and understanding throughout the difficult period prior to the birth of their son, Sean. The application for deferred action was considered by a special deputy district director appointed at the time and passed muster. It went on to the regional commissioner, who also recommended it, and the newly appointed commissioner of immigration granted it. This took place just 2 weeks before the Court of Appeals considered my appeal from John Lennon's deportation proceeding and the affirmation that the Board of Immigration Appeals had entered. And in that case, we were granted, we were eventually granted residence. At long last, John Lennon had been declared a person first as a non-priority case who would be allowed to remain in the United States, and then later on had a case being remanded from the circuit court to the BIA, which remanded it to the original immigration judge. His case came up for consideration, and the judge exercised his judgment in his favor, and Lennon was granted permanent residence in the United States. Talk about prejudgment. I had so much prejudgment in Lennon's case that I had an idea for the last hearing. I suggested to the attorneys who were representing him at the end before the immigration judge that they actually print up a green card for him and award it to him after the hearing. I said that you've done so much damage in this case and you've hurt these people so much, at least do something that will make you look a little better. And they did that. And one of my favorite pictures is the picture of us leaving the immigration service, going into a car, and Lennon is holding up his green card. I can only say that John Lennon not only became a permanent resident of the United States, but in the process provided us with enormous help in securing a remedy which has the potential for assisting thousands of other non-citizens of the United States. What a contribution he made to his adopted country. Thank you.